First of all, can you hear us?
Yeah, we can hear you. Yeah.
Oh, great. So I decided to fly to Heidi in San Francisco instead of flying into what might be no big deal of a hurricane. But thank you for standing by with that. So I don't know, have you done any introductions yet, or should we do that?
I have introduced you. Please proceed.
So you've done the introductions of Maura and Stephen and Heidi. And
Very brief ones, but I wanted to give it to you to talk about the important parts of resolving cases.
Well, I'm sure you've covered it, so I'll just launch right into the subject matter. The purpose of this panel is to talk about something that I don't think is talked about enough, and it is all the other goals that litigants have after a plane crash. And I put together this panel because I felt like Stephen could provide the defense perspective, Maura can provide the insurance perspective, and Heidi can provide the perspective from a family member or victim of a plane crash, a litigant. And then I'm obviously providing the plaintiff's perspective. So hopefully we'll have a well-rounded, just sort of all different viewpoints. But we also want to throw it out to participants at Abacon to know what your experience has been with this particular subject. So if we want to start on the first slide, it should be a chart that says that 41% of plaintiffs don't care about money. So what this comes from is there was research done in Canada of 141 people who filed medical malpractice claims. And in filing those claims, they were monitored by the government of Canada, they were interviewed, and there was extensive work that was put into figuring out why do people sue. And what is really interesting is that the work that all of us do, it really just involves getting the money. So what about all these other goals? In terms of my practice, when I do closing argument in a jury trial, I like to educate the jury about how our system was created, that our founding fathers fought for the jury trial system. And then I have to educate them about how we compensate people. We compensate people with money in our society. If you break the Mona Lisa, you owe the government of France $700 million, I like to tell them. So when we get to that jury trial, and I'm standing there telling them that they can only award money, I feel somewhat disingenuous. Because all the way up until we got to trial, we could have done something different. We could have met these other goals in settlement. And what is unique about settlement is that we can weave in some of these other goals. We can weave in things like apologies. We can weave in things like changes to manuals. We can weave in things like acknowledgement, which may be a memorial. So we really have years sometimes of having these opportunities. So I thought Abacon was a perfect place to talk about this because really let's go to the third slide. The goals of litigants in a plane crash, I think the number one thing, and we'll talk about this, is the search for the truth. So when a plane crashes, oftentimes no one knows what happened. And there's a lot of information as a family member you want, and Heidi will talk about that. Another goal is to create safety, to make sure that we never see the same accident twice. I don't think anyone is more motivated than a litigant or a family member, except for the airline or the operator or the manufacturer, to make sure that never happens again. And part of that is a way to bring meaning to the loss. It didn't happen for no reason. It's just part of how people think. Taking responsibility. I think that goes hand in hand with apologizing, but it's part of the just how things resolve in terms of closure. People, we know this about ourselves, we're able to move on when we feel like we can forgive. And until we get to that place where we feel like we can forgive, a case might just keep going on and on for us, or an issue with a friend or whatever. And then to remember and honor the person who is lost, which is another way of obtaining closure. So these are a lot of the goals that we see, and Heidi can talk about more about these, that we see with people who start the litigation process. As lawyers, we step on the toes of our own clients and of whether it's a manufacturer or an airline or a person, because we have been conditioned to think only about money. We've been conditioned to think, okay, this person was making this much per year and they would have lived this number of years and a jury's likely to give them this, so let's just break it down into a monetary unit. And we really don't do our clients or the system justice when we think that way. So this entire panel is meant to really get people thinking about this aspect of resolving claims. That, and this is just, I'll give this one quick example and then we'll start to move into the other folks on the panel. But there are so many times when a defendant, an insurance company will say, please take my policy limits. Here's the check. Please take the limits. And I have to say no, because strategically, I want them in the case. I want them in the case for different reasons, whether I'm worried about joint and several liability, or whether, I like it when defendants fight between themselves, or whatever the strategy. There'll be so many times when the defendant says, please just take this check. And I have to tell the client no, and here are all the strategy reasons why we're not going to do that. But and we all know that we have to communicate the entire settlement offer to our clients. If a defendant came and said, and we also know that when we have settlement discussions, they're non-admissible. So if I got a letter from a defendant and it said, here's the policy limits, and as part of the settlement, we want to apologize to your client. Or as part of the settlement, we want to see what they want us to change, whether it's this procedure or this manual or this inspection process. If that happened, I would completely lose client control, and they would say, yeah, we're going to settle with this entity. And I've had instances where my clients would say, well, I know you're telling me not to take the settlement, the limits offer, but if they also combined it with this, I would. And then I tell them, oh, well, they'll never do that. We're asking, then we ask, and they say no. So I also want to explore why we don't do that. Why do these insurance company, or why does the airline not do that? So what I'd like to do, and then finally at the end of the panel, I'd like to give some examples of what we're doing at my law firm to address these other goals. We have some concrete and really exciting examples of ways that we have made safety changes with different entities or memorial, other changes that we're seeing. So we really do, at the beginning of the case, we make the goal of ours to sit down and find out what the goals are of our clients, and we want to get them not just the money, but meet their other goals. So I think with that, I would like to turn it to either Maura or Stephen to talk about, and what's interesting about Maura's experience is she can talk about it from the insurance perspective, but she also lived in Japan and worked in Japan, where apology has a different meaning and culture. So I hope that she can talk about, her experience with when claimants want more than money and how does that work, and also what she has seen and experienced in Japan. And then Stephen has prepared slides that talk about some of the case law and examples of when it doesn't work. Sorry, jump back. In terms of our agenda, I actually have Heidi next. So I am going to turn it to Heidi to talk about her experience with what families really want after losing a loved one.
So there's our first slide. So I'm just going to give you an overview of the organization, Access, and what we do, and what we've learned over the years. So I started Access Aircraft Casualty Emotional Support Services back in 1996 after losing my fiance on Flight 100. And one of the things that we learned is that we really needed other people who had been through a similar loss to help us get through it. So I had a lot of care from families from Pan Am Flight 103, which happened 8 years earlier. And I was paired up with a fiance, and she helped me so much, just validating everything I was going through. And after doing that, I brought it to Giuliani Williston office, and I said, I've got a lot of care from these Pan Am families. And he said, well, we need something like that because I never know when the next plane's going to go down by watch. And unfortunately, after that, there was Swiss Air, there was Egypt Air, of course, 9/11, Alaska Airlines, and a bunch of incidents. And so our organization, unfortunately, grew really quickly. And so we developed a base of people who had been through aviation loss to have on call to then be there for newly bereaved families. So we pair mothers to mothers, siblings to siblings, spouses to spouses, and other relationships lost to make sure that people have somebody further along in the process than they are to help guide them as to what to expect from the emotional side and the grief side of things. And well, if you go into the next slide, here's an overview. Like we have 250 grief mentors who are on call, who we maintain, who are trained, who are there for the family. So when somebody calls our helpline, they say, I lost my son, he was such and such age. We then pair them up with somebody else who's been through the loss for at least 2 years, who's gone through our training program to be there for them. And from doing this work, I interview a lot of the families because I find it so important to share what was helpful for them in receiving care from airlines and attorneys who work with them. What is it that they actually need from that? So I think that ties in well to the topic today of other things beyond money that they do need. And we have had a lot of people, come forward with their wanting some sort of apology or acknowledgement and determining how that can actually be done within your infrastructures from insurance and from being on the defense side. I think it's a challenge because I understand that, of course, you don't want to come forward admitting fault or anything like that, but I do believe there are ways that it can be honored and acknowledged what they've gone through without admitting guilt or anything like that. So that's something that I appreciate this panel being on the other side of it, that at least has set this up, because there are aspects of it as far as wanting to change things or having memorials put in place or other things that can be done to honor families in addition to the settlements that really do make a big difference for them in the long run. And so we can go on to the next slide. And so since with that, we've dealt, because of all the interviews I've done, we've put together a book which outlines what people found most helpful and most hurtful after their losses from the people trying to care for them, such as care teams at airlines, but as well as attorneys and people who have to conduct business with them after such a tragic loss. So we spent a lot of time getting the data of what was most helpful, what was most hurtful, what do people say to people that made them trust them. Because it's really important that your clients trust you. And we found from interviewing our population really what they needed from those in positions of helping them. So we can go to the next slide. And so some of the things that we've come up with, but we do more extensively when we train airlines and various firms, but it's really, it's so important for our families to say you're sorry. And it's very basic, but if there's a way you can do it in a way that is acceptable for your firm or company, it's really something to look into, figuring out how to best do that and to honor what happened to these people, regardless of the cause that happened. A lot of the families will say that they really found it important that the person they're working with actively listens and acknowledges that they lost somebody. And even if it's not what their role is, it's really important that they feel heard by the person trying to help them on business matters such as an attorney who has to deal with important business matters, but at the same point, you not put aside the fact that they've gone through a very life-changing experience. And most importantly, what we've found over the years, and what has worked, is a lot of airlines refer their clients to us for care so they can get back to their normal business activities, as well as law firms, because we're just a value add. We're not one or the other. We're here to help supplement the work that we do. And with the goal of making it easier for you to work with them, since most of your roles are not brief, it's not something that you're designated to do. It's just really important to give them the resources to get the care that they need for their specific requirements, or whatever it is that they're going through, to help them find the care that they need. And I can't tell you how many law firms we've worked with who send their clients to us, and they always just call us thanking us for being there for them. And again, it's supplementing what you already do, but it can really make your job easier if you can outsource the brief work and not try and be a jack of all trades.
Oh, and so Heidi, do you have any more slides, Heidi?
No, I think that's it.
Okay. So Heidi also, they also train airlines, and she was telling me about an airline that has asked that their access be on call in case of an incident. I think those are all great ideas. So I guess I'd like to turn it to Maura or Steven to talk about, what are some of the hurdles when people ask for more than just money? What are the problems?
Thanks. I think so. Of the areas that you listed of different types of non-monetary relief, I think the one that's we're most likely to find consensus is on the apology issue. So if we have a situation where one of the plaintiff's goals is to obtain an apology, I think in the appropriate case, the airline or the manufacturer can issue an apology letter, and we've done that in some of our cases with Schneider. Now, what qualifies as an appropriate case? I'd say generally it's where there's no dispute that the plaintiff has suffered some kind of injury. And then regardless of who may be at fault, the airlines don't want their passengers getting injured on their flights. The manufacturers don't want injuries created by their products, and they're genuinely sorry when that happens, regardless of fault. So, and I think a good example from the conference hypothetical would be passengers on the Air Apparent flight who were injured in a brawl on the aircraft. I don't think anyone would say that was the airline's fault that happened, but they're still probably sorry that the passenger was injured in that incident. So we have, in cases like that, we have worked out letters of regrets, and we've been able to issue apology letters. The key, in my mind, is that you want the settlement agreement to include the verbatim, precise, agreed-upon wording to avoid any dispute down the road about what exactly the letter is going to say. And if we can get to the next slide, this is an example that I anonymized that I pulled out of a settlement agreement. This is paragraph 3 of the settlement agreement. It says within 30 days, the defendant will send a letter to the plaintiff through a counsel that states, "We are pleased that we could reach an amicable resolution of the claims you brought. Although each side's memory of the events of that date varies greatly, please know that regardless of those differences, defendant is sorry for your loss." So this is an actual letter that we issued in the case, and we worked out the wording during while we were negotiating the settlement with the claims counsel. I'd suggest that an even better practice, and I'm basically saying that to myself because I was the one who wrote this, an even better practice would be if there's issues about, is this letter going to be on letterhead? I should probably say that in the settlement agreement. Who's going to sign the letter? Does it kind of care exactly who at the airline manufacturer signs the letter? Well, let's put that in the agreement so there won't be any dispute down the road. And an alternative way to do it is to actually draft a letter. Put it on letterhead, read all the terms, draft it up, put the name of whoever's going to sign, and then attach it as an exhibit, unsigned, to the settlement agreement and say this is what we will send to you executed within however many days. And the next slide is an excerpt from one of those. And so in this particular case, on behalf of the defendant, we deeply regret the incident that occurred during the flight at issue. And then the next paragraph is an acknowledgement that the airline had not met their customer service goals in that particular case. And we are pleased that we were able to reach an amicable resolution of your claims. We look forward to future opportunities on our flights to earn your confidence. Now, I will suggest that many times you're having these discussions during a mediation or during a settlement conference, and it's the end of the day, you're tired and you're hungry, and the magistrate judge wants to send his staff home, and you'll very much wanted to say, okay, you know what, let's work out the details of this letter later. Saying resist that urge, try to get it done at the time, because all you're doing is inviting problems if you can't nail it down when you're actually agreeing to the settlement. So the point I'm emphasizing about having all these terms, the terms of non-monetary relief nailed down in the settlement agreement is critical because, in my view, it goes to one of the defendant's main goals in settling the case, which is finality. You want your defendant wants the claim fully and completely and finally resolved. They don't want any further disputes with the plaintiff. They want peace. And the failure to nail down the terms of the monetary relief can put that goal in jeopardy. And what I was able to do is find a real-life example to illustrate this point. It's the Macario case, which is going on 30 years old at this point, so some people might be familiar with it. But on the next slide, so the Macario involved a crash resulting in a fatality. The estate sued Beach and Pratt & Whitney, and when Pratt settled, they included a non-monetary provision in the agreement, and that was that Pratt would issue a service bulletin as soon as practical, informing the owners of the engine at issue in the case that the installation of P3 filters could reduce the likelihood of the failure that allegedly contributed to this particular crash. And so, did this settlement accomplish what I assume was Pratt's goal of achieving peace with the plaintiff? It did not. Take a look at the next slide. So the FAA had some safety concerns relating to installing the P3 filters in the subject engine. So Pratt delayed issuing the service bulletin while the FAA investigated those concerns. The plaintiff then sued Pratt for breaching the settlement agreement because they didn't issue the service bulletin, and a very long and contentious litigation about the breach of the settlement agreement followed. So there were various motions relating to written discovery, and on the next slide it talks about the plaintiff had moved to compel the depositions of Pratt's trial counsel and the deposition of an attorney from Pratt's insurance company, and then Pratt moved to compel the deposition of the plaintiff's counsel, and there were all kinds of motions relating to expert witnesses. And at some point, Pratt then moved to stay the whole case pending the resolution of the FAA's investigation of the safety issue, which the court granted. At the conclusion of that investigation, the FAA then issued an airworthiness directive requiring the removal of these filters from the engine. Pratt then moved for summary judgment. That motion was granted. Plaintiff moved for reconsideration. That motion was denied. The next slide, Third Circuit affirmed the motion for summary judgment. Plaintiff moved for rehearing. That was denied. It went back to the district court where the plaintiff filed a Rule 60 motion. The Rule 60 motion that was denied. It went up to the Third Circuit. The Third Circuit affirmed the denial of the Rule 60 motion. Plaintiff eventually filed a cert petition in the Supreme Court, which was denied. And by the way, during this time, there was a whole separate related state court proceeding on several issues relating from the settlement. So in this situation, an attempt at non-monetary relief resulted in a massive litigation. And as a side note, and I have no idea, but I wonder whether the litigation, the breach of contract litigation, you breached the settlement agreement, is that an insured claim? Maybe, maybe not, but it's possible that this was several years of litigation on a claim that wasn't insured, that arose from an insured event. Now, when the panel was discussing this ahead of time, Elisa asked me if I could come up with a way, in retrospect, to draft around the problem that came up in the Cario case, and I'm always up for a challenge, so I gave it a try. And if you look at the next slide, this is what I come up with, and frankly, I'm not crazy about it, and if we have some time afterwards, maybe we can discuss if there's some other way to do it. But language along the lines of, no later than a certain amount of time after the settlement agreement goes into place, Pratt will request that the FAA confirm that it's not going to issue an airworthiness directive, and then if they do confirm that in writing, Pratt will then issue a bulletin, and you agree on the exact language of that bulletin. And if the FAA doesn't issue that statement, or in any other way says you can't install these filters, then Pratt's off the hook and doesn't have to issue the service bulletin. And I have no idea whether the FAA would do that. I mean, if you ask them to kind of say, I'm not going to issue an AD, I don't. People in the room might have a better idea than I do, but that seems somewhat unlikely. And I drafted this in a way, being a defense lawyer, that's pretty protective of my client, where if I don't get the confirmation, my client's off the hook and they don't have to do this. I'm guessing a lot of the plaintiff's lawyers might not agree to language like this. So if anyone has any other bright ideas, we happy to hear them. But the other problem with this, of course, is that I have the benefit of hindsight. I know exactly what the problem was, and I can now try to draft language to cure that problem. I wouldn't know that at the time, and if I'm drafting this without knowing what's going to happen at the end of the day, I probably want much broader relief about all the things that could go wrong, and if there's a way we can kind of draft around that. So the take home for me is I think you're much more likely to reach an agreement on non-monetary relief if it's the kind of relief that you can draft in a way that doesn't have an open-ended potential for future disputes. Because as defense counsel, I'm going to be very reluctant to recommend that a client agree to any type of non-monetary relief that carries the risk of potential future litigation.
How about you, Maura? Thank you very much, Steve, for that.
So, as much Elisa as I would love to settle cases with you without opening my checkbook, that doesn't usually happen. And really, once it gets to the insurance company, a lot of the apology possibilities have almost already happened, because sometimes, especially in airlines claims where things don't immediately go into litigation, claims can discuss with the insured directly regarding whether or not an apology is something that they're willing to do, if there's some focus group that they're willing to have to discuss their policies, which I know it's not something that they like to do, but I think a lot of times focus groups are a way to get around that. As you said at the beginning, I want to be involved in drafting your policies and procedures so that something like this doesn't happen again. Well, once things are in litigation, you're not going to be able to open up the doors to any plaintiff that says, hey, I really want to be involved in policy making for your company. That would be time consuming. It would probably, I don't think it can ever be cohesive because there would just be so many different ways of people thinking that they know best about what their policies and procedures would be. And again, at the end of the day, you filed a lawsuit, and I don't think that any company is going to want to open the doors to plaintiffs' counsel to have free reign to shape policy and procedure. But at the same time, I think we have a lot of the same goals as far as not wanting things to happen again, wanting to, even if we can't admit, even if we don't think that we have liability or that we're the most culpable party, we can certainly say things like, we regret that this incident has happened to you. We take your feelings seriously about the fact that this is something that has happened to you. We will do our utmost to assist you in finding the culpable party, or whatever you need from us that can help you this way. But that's something that we have to work very closely with our insurers about, mainly because once it gets to the insurance company, we really are the money people. And that's another thing that I think that our insureds can sometimes throw the insurance company under the bus, right? And say, you file a lawsuit, it's an insured claim, whereas we regret that this happened. This is now about money a little bit more than it is about anything else. We've said that we regret this incident. We've said that we will take a look at policies and procedures. Maybe we will do a focus group, but at the end of the day, it is going to be a little bit about money. I have a case right now where there's a man who, it's a very small airline case, and he says that he was seated next to a passenger of size, and that because he was seated next to a passenger of size, he breached the contract of carriage by not allowing him to have a full seat that he had paid for. And part of his settlement is that he wants us to assure that he will never be seated next to a passenger of size again. That's just unrealistic. And this person's actually someone in the legal community, so he should realize that that's an unrealistic ask for something like this. When we were talking about this beforehand, one of the other asks that I get pretty often, and I've had judges say, I don't understand why you can't do this. People will actually, and this happened a lot more years ago, but people will say, hey, you know, like in Lost, when the Oceania Airlines gave him free first class tickets for life, I want that. How can you how can you quantify something like that? You can't, because there's so many things that could happen. The airline could go defunct, and then are they missing out on some sort of compensation that they should have been given? And maybe you can draft that into a release. Okay, well, we'll give you free airline tickets for life unless X, Y, and Z happens. But there's so many contingencies to that it's just an impossible reach for things like that. So from the insurer and the insured side, unfortunately, the way that the legal system is set up, it is often a lot of times about money. Because I also, like I said, as the insurer, once it gets to me, any chance of just an apology has already happened, and now it is about money, and maybe also the apology, but I've rarely seen a plaintiff say, if you just say you're sorry, then go away. They at least want miles or a ticket or something along those lines, which is fine, and if something actually happened to them, they should be compensated. And that's another thing that I think sometimes the insurance companies and maybe the insureds, if we do think that there was something that was not handled properly, we do want to make it right. And there is a customer service sort of basis for that for us. And if it's something more catastrophic, like a crash, we do have family assistance programs in place that, like Heidi's company, that can help out and will go immediately as a go team to the crash site to start setting up call centers and things like that. So I don't know that we're against having alternate resolutions to things. It's just, as Steve said, really hard to then end the case and close the file, because it could be majorly open-ended.
Thank you, Maura. If you don't mind turning to page 4 of my PowerPoint, the page should look like recommended reading, lawyer conditioning. Let me know when we're there. Okay. Our job is to resolve claims. Whether you work for an insurance company, or whether you're an airline or manufacturer, whether you're a plaintiff's attorney, what do you do? What do you do all day as an aviation attorney? I resolve claims. So I think that it's kind of funny that we don't spend very much time working to really understand how to resolve claims. We think, well, that's a mediator's job. Mediators are supposed to brush up on all that business. But I think if you really want to be taking the practice to the next level, it's worth reading articles like this article, Tamarillis, It's Not About the Money. That contains a lot of the data that, the empirical data, as she refers to it, from Canada. So you can understand, what do people actually want? She actually wrote a book. The next slide is, this is something Maura sent me as recommended reading. The use of the apology in Japanese culture, and it does have a section on an airline in Japan resolving plane crashes through apology. But then the next slide should tell you the name of the book, Perceptions in Litigation and Mediation. It's an amazing book that actually even talks about it by gender, what female litigants, what's more important to female litigants or male litigants. And that surprised me too. So I think it's worth at least learning about what are the other goals of people so we all can resolve claims. The next slide is, this is a picture from one of our cases that my partner Ken Friedman handled. So this shows a crosswalk, and in the Pacific Northwest, it's often dark when school starts, and we had a client who, she was walking to school with her brother, and she was hit. It was pretty dark out, and unfortunately her hair got stuck in the drivetrain of the truck, and she was scalped. And luckily she survived, but a horrible, horrible incident that ended up in a trial. And midway through trial, the case settled, but the family and I'm proud to say my partner Ken refused to settle the case unless the county agreed to put a light next to the crosswalk. And so that was the non-monetary goal that was achieved. And I was talking to Ken before this presentation, and we were both talking about how when we look back on our cases, it's not the case where you get millions and millions of dollars for your clients that you feel most proud of. Almost it's the cases where you change something that you like to brag about the most. So this is my opportunity to do that. The next slide is one of my cases, and I represented a plaintiff from a helicopter crash in Peru that killed 7 people. And the attorneys at Perkins Coie were awesome to work with in our mediation because they really understood my client was not going to settle unless a memorial was built at the expense of the defendant for the entire crew. And that was all we had to say. We did put into the settlement agreement that the defendant would fund the memorial. And then I've checked in with my client over the last year and a half, and the memorial is nearly complete. She has had a really amazing and closure-giving experience working with the defendant to create this memorial. There's a plaque, and I didn't include all the wording on the plaque because I don't know what the final says yet, but it basically says, this interactive installation honors the flight crew of this number helicopter. They lost their lives on this date, blah, blah, blah. And it includes binoculars and other educational pieces in the installation that kids can use. And she feels really good about it. And then the last slide is we are working on non-monetary aspects of M17. So we represent some of the folks who lost their lives in that attack, which involved a shoot down over the Ukraine, and trying to figure out what an amendment to Chicago or Montreal would look like to give claimants a place to bring their claim if a family member dies in this way. There's sort of a gap in the treaties right now. There's no, the International Court of Justice is from state to state, and there's really no place to go. So that's something that's extremely important to many of the families who are involved in that, in a way to really move things forward. So I would love to open it to questions or even just comments that people participants have about these ideas. Has anybody ever done that? Has anybody ever gone a non-monetary aspect in a settlement?
Lisa, Rick Alamonte had a question.
Hey Lisa, how are you? Yeah, that was a
Hi, I'm wondering.
just a comment. Very often in mediations, especially in a GA case, where there is a potentially culpable insured, not that that's not true in every case, but the airline cases I think are a little different. A lot of time, like Maura said, by the time it gets to you, maybe the time for apologies are passed. But very often reflexively in the mediations, the defendants show up with the insurer and no one else. And that's a place where, especially in a GA case that's not too old, and it's a very personal case, maybe just one serious injury or fatality, it's really important to consider bringing a representative of the actual client, the insured. Recently we had a mediation session. I think it took a second or even a third session to ultimately resolve the case. The first thing that the family of the deceased minor wanted to know was what had been done to prevent this from happening a second time. It was sort of a lapse in procedures that had caused the accident. It was a poor spacing of aircraft in a fly-in type event that caused the accident. And really the whole day was almost consumed, and this is not a negative in my mind, in dealing with what precautions have been taken. So I just, sometimes we as defense lawyers, in our checklist of do I have the decision maker with me, we think that we do by just bringing the insurer. And I think very often it's important to, at least if you're not going to bring someone from the actual entity involved, communicate with the other side to find out if that would be productive. But very often, just a few words from that entity, this is to the effect of this is a horrible thing, we feel really terrible, and then backing that up with some affirmative progress towards preventative measures can really set the right tone to get things done. It may not even require that any non-monetary compensation be part of the settlement agreement. But if they feel that this has not been for nothing, and that there are in fact changes that have been made, it's already part of the settlement. And I think that we just have to be careful about taking a very broad approach. So I have my insurance carrier, so we're ready to go. Because very often I think even just the presence. I insisted that I was not that particular party. I was representing someone else. But I insisted that my client, even though we had pretty much an agreement to get out for our limits very early in the case, I insisted my client be insured attend every mediation because I just wanted the family to see that this was important. This was something they were going to send somebody to make sure it was resolved. So just thinking again on the defense side, it's important to have the right people there because that non-monetary relief is not necessarily, and often not at all, going to be something that an insurer can provide.
I agree with that. I think that especially in airline cases, a lot of times the families, or the injured party just wants to tell their story. They just want their side of the story to be heard and not through lawyers and to speak directly to someone at the airline, regardless of the fact that it might not be in this very specific department that they think that the cost that they blame for an incident, or if there was no one to blame at all. But just to be able to sort of say, this really was horrible for my life or affected me greatly. And so just to see that somebody from the airline is there listening and taking it seriously, with sort of the media attention around Mark Zuckerberg's sister, who claimed that she was sexually assaulted on the airlines by, I think, an overserved passenger, and that she was not pleased with the airline's response to that. And especially in the Me Too era, I think it's important to have someone from the airline there that says, well, even though we weren't
into a case, especially in a case where a family has lost a loved one, you can think as a plaintiff's lawyer, you prepare your client for mediation, and you know that money is the only compensation that the law allows. It takes a while for them to adjust to that in mediation. And particularly when you start getting into negotiation, it can often almost be a setback. They realize, we're quibbling over, a few $100,000 about the value of my husband's life. And so we on the defense side, and the right mediator as well, really have to always sort of soften that and start out with, you realize, something along the lines of what was brought up in the beginning. Money is what the law offers. There may be some non-monetary aspects as well, but it's really important to understand the perspective from the other room, and that they may need to it may take some time for them to just embrace the idea, and embrace maybe the wrong word, that at the end of the day, it's going to be money. And certainly something else can really help to extend it to the right way.
Thanks, Rick. I think that's really well put. I mean, I think what I was trying to convey is when we get to trial, those are all the tools we have in our toolbox. When we get to trial, we only have money. But until we get to trial, we have all these other ways to resolve the case. And we all share the same goal, which is we never want to see this happen again. And we all want finality. And, I never want to see the same type of injury, caused injury. The worst for me, I think this all started years back with children who are burned on flights. Children who are burned on commercial flights. I just feel like every time I get another case involving a child who's burned on a commercial flight, I personally feel like a failure. Because, this may sound silly, but what have I done to stop this from happening again to another child? So if you take that to, to a different place, whether it's a carburetor that keeps failing or some product that keeps failing, if we keep seeing the same case over and over again, I think that all of us together, defense attorneys, plaintiffs' attorneys, parties, we're failing. So I love the fact that we've had this time to talk about ways to elevate our profession so we do more winning. And thank you for putting up with having us remotely. I hope that's worked for folks.
Thank you.
I was just going to say, you always hear we want an apology, but we had a mediation in December where my client was wrong. We're looking at punitives, and plaintiff refused to allow my client to apologize to the family. Refused to allow them in the same room to do that. And to me, I felt that it was because, number one, my client really wanted to apologize, but number two, I felt the plaintiff attorney didn't want it to happen because it hurt his bottom line. And that's how I felt on that case. So, that's it, just a comment.
Well, thanks, guys. Heidi and I are going to go out for beers now.